the trade-off for the purchase price and ultimately getting some money is the buyer's going to want some protections from you. So they will manage their risk through a series of things such as warranties and indemnities. Probably terms you've heard before in some context, and I would say that by the time you get into heads of terms, you'll probably be familiar with them quite quickly. The general essence of warranties and indemnities is that they allow the buyer to recover part of the purchase price from you if certain things happen. Now, warranties are generally the buyer's way of contractualizing the due diligence that they've done. And they are a series of assumptions on which they've bought the business. So they will want to make sure, for example, that you own what you're selling, that you've got proper regulated contracts in place with your clients, that you haven't got any issues relating to your branding or matters relating to staff compliance or disciplinary processes ongoing. And within that purchase agreement, they will set out all of these assumptions throughout. And there will be a process that you will go through with your solicitor where you will talk about where those assumptions are not correct. And you will need to formally disclose against those to make sure that the buyer can't come back to you after the event and say they didn't quite know what they were buying. Now, if it turns out afterwards that you don't properly disclose and you don't rebut those assumptions correctly, and the buyer loses out because, let's say, there was an employee disciplinary issue that they weren't aware of, and then the employee is entitled to some money, they could come back to you and ask for you to pay that.